Hello, inventors and entrepreneurs. On this episode, we're going to be talking about provisional patent applications. What is a provisional patent application? What's the difference between a provisional patent application as opposed to a non-provisional patent application? What do you have to include in a provisional patent application in order to file it? Is there something different that happens to a provisional application after it's been filed as compared to a non-provisional application? Here's the big question you're all asking. Is it true that it costs a lot less to file a provisional application than a non-provisional application? But most importantly, when do you file a provisional patent application as opposed to a non-provisional patent application? Those are the things we're going to be talking about, so let's get going. Hello everyone, I'm Elias Borges. I'm a patent and trademark lawyer, and I've been protecting intellectual property for over 30 years. On this channel, we discuss tips and strategies for maximizing the value of your intellectual property so that you can grow your business and build your brand. If you're new to the channel, you should consider subscribing. Oh, and at any point during the video, you should check out the comments and the notes below for additional links for additional information. Let's get started. So what is a provisional patent application? Well, essentially, it's kind of like a quick, streamlined patent application that you file in order to secure an early filing date. It preserves your patent rights and allows you to use the term patent pending. But here's the key thing about provisional patent applications. In order for them to be effective, you have to follow it up by filing a non-provisional application within 12 months of the day that you filed your provisional application. So remember that date, 12 months. So how is a provisional patent application different than a regular non-provisional patent application? Well, it's generally more streamlined. The drawings don't have to be as elaborate. The description very often isn't as detailed. It doesn't have to have patent claims. Now, oftentimes they do. The other thing too is that they generally have a lower filing fee, and there are simpler forms that you have to file along with the application. It's generally an easier thing to do. Now, what has to be included in a provisional patent application? Well, of course, you have to have some type of description which describes what the invention is and how it works and what the component parts are. Usually there's drawings to help illustrate, this is what the invention looks like, these are the various bits and pieces, and that drawing is usually referred to in the specification to try to explain what the invention is. You also have to include such things as the name of the inventors, the residential address, that sort of thing. Now, technically, it doesn't have to have claims, but oftentimes we do include one or two claims to help define what the invention is. So after you prepared all the constituent parts of your application and you file it, what happens then? Well, if you file it electronically in the U.S. Patent Office, you will get a confirmation that the application was filed, and that confirmation will have an application file number as well as a filing date. Usually a couple of weeks after that, you'll receive in the mail a document which basically is an official filing receipt specifying who the applicant is, what the title of the invention is, the application number, and the filing date. And that's basically it. Nothing happens to the application after that. They don't examine it. They don't do a patent search. Usually, you don't have to do anything to the application after it's been filed. So to answer the question that you're all asking, does it actually cost less to file a provisional patent application? Well, technically speaking, it does cost less. Because the application is streamlined and the specification usually isn't as detailed, the drawings don't have to be formal, they can be quite informal. Because of all of that, it generally takes less effort and therefore less cost to prepare the patent application. Also, the government filing fee is a lot lower. Again, there are also fewer documents that have to be filed along with the application, so there's less work involved in filing the patent application, and that usually translates to less money to prepare and file the patent application. How much less really depends on the facts of the case. You're looking anywhere from a quarter to a third to a half of what it usually costs to prepare and file a non-provisional patent application. But there is a catch. Like I said before, you have to follow up that provisional application by filing a non-provisional patent application. Now, you still have all the costs associated with preparing and filing a non-provisional application. You have to have a detailed description. You have to have detailed drawings, and they have to be in the proper form. You need all these other forms. You need detailed claims. All of that has to happen as well. So in a sense, it doesn't cost less. In fact, it may cost more, because if you're going to file a provisional application and then file the non-provisional application within 12 months, it ends up actually costing more. So it's actually less expensive to simply file a non-provisional application and forgo the filing of a provisional application. So this raises the question, why would you ever file a provisional patent application? Well, generally speaking, we do it in a couple of scenarios. First, you have an urgent filing deadline. That is, you publicly disclose the invention, or you're about to publicly disclose the invention, and you need to get something on file to preserve your rights as quickly as possible. Well, the best way to do that is with a provisional patent application, because it can take weeks, sometimes months, to prepare a non-provisional application. Sometimes getting the drawings can take weeks or even months, going back and forth with inventors, going back and forth with the client and the patent agent and the patent drawing draftsman. All of that can take a fair bit of time. So a provisional application can speed things up by getting a streamlined application on file quickly. Now, the second scenario where you might consider filing a provisional patent application is when you're thinking of an idea or a product or some kind of invention of some sort, and you're very interested in trying to preserve those rights because you want to do some exploratory marketing, maybe some exploratory development or talks with potential investors, and you don't want to give away your rights too early. So you can file a provisional application which gives you an early filing date, and then you can do these other things which will help you determine whether or not it's even worth going ahead with this project. So if it's not worth going ahead with the project, then you can say, well, we're not going to go ahead with filing a non-provisional application, and basically nothing happens. The application, the provisional application, the 12-month period passes, you don't file a non-provisional application. For all intents and purposes, it's as if the provisional application was never filed. So in that scenario, it may be a good idea to file a provisional application when it's really tentative as to whether or not you're going to go ahead with a non-provisional application. So are there any risks associated with filing a provisional application? Well, not really. I mean, other than the cost associated with filing the application, there really are no risks. If you decide not to file a non-provisional application, it'll be as if the provisional application was never filed. The provisional application is never published, unlike a non-provisional application, which is published within 18 months of filing. So you don't have to risk that. So basically, other than the costs of filing and preparing the provisional applications, there's basically no risk associated with filing a provisional patent application. So, in conclusion, a provisional patent application is kind of like a streamlined patent application, which is relatively cost effective, and it does preserve your rights, and it gets your rights on file as quickly as possible. But it is no substitute for a non-provisional patent application. So that's provisional patent applications in a nutshell. I hope you enjoyed the video. I hope you found it informative. If you did, please give me a like. I'd really appreciate that. If you know of anyone who might be interested in watching this video, please share the video. Also, take a look at the notes below because there's additional links for additional information on intellectual property and provisional patent applications, and there's also a link to my website if you want even more information. So here's the question of the day. Do you think it's worth filing a provisional patent application, or should you just go straight ahead and file a non-provisional application? Please let me know in the comments below. I'll see you next time, and until then, keep inventing the future.